Hello, friends and clients of JLW Immigration Law Group. I am Jennifer Walker Gates, board certified immigration attorney, and I'm here today to talk about fiance visas. We are doing a little series on fiance visas, how they work, what are the steps to get from a fiance visa all the way to permanent resident status. And today I'm going to be talking specifically about the requirement that you have met in person 2 years before you file that I-129F form for your fiance. So we're going to be talking about that requirement, what it is getting at, why it's there, and if you can't meet it, haven't met it, how to get around it, how to overcome that requirement if you simply cannot comply. That's what we're talking about in this video. Before we get into that, please take a moment and subscribe to our channel, share our videos, like our videos, leave us comments. We do respond to the comments, and our hope is to share good, reliable, trustworthy information with the immigrant community across the U.S. We want everyone, whether they're working with us or another attorney or filing on their own, to have good, high quality information so that they can be successful in their process. Please help us with that by subscribing to the channel, leaving us a comment, leave us a like, and if you know somebody who could use this information, please be sure to share it with them. I am going to click our information, our contact information, so that it's scrolling across the bottom of the screen. So if at any time you need personalized advice about your case, please reach out to us at either our website, jlw.law, or at our phone number, 512-633-1785, and one of our team will get you scheduled with me or one of the other attorneys in our office so that we can help you understand what exactly your case requires to get across that finish line. Today, fiancé visas. As many of you probably know, in order to receive a fiancé visa or get a fiancé visa for your beloved fiancé, you have to file Form I-129F, and that form initiates a process that ultimately results in that person being able to come into the United States, get married, and then file for permanent resident status. It is important to note that Form I-129F has some requirements that are absolute, that definitely must be filed when you submit the form. If you don't have these bits of evidence when you submit Form I-129F, your form may be rejected. It may be sent back to you in the mail, which creates a lot of opportunity for loss of your filing fees, for loss of the evidence in the mail, for delays and other complications. The other thing that can happen is your case can be accepted by USCIS, but then you get what's called a request for evidence. That also can create delays and potential complications. Or you can get what's called a notice of intent to deny, which is a very quick turnaround, basically like a request for evidence, except you have a much shorter time frame, and it's a harder, higher burden to overcome. If they're sending you a notice of intent to deny, it means you have one last shot to save your case. So it's really, really important to make sure that you submit all the evidence that they want when you submit your I-129F. That will include what is listed in this banner that is on the screen right now. First, the identity documents of the petitioner and beneficiary. You want documents to show your birth, your place of birth, your manner of birth, in other words, birth certificate, if at all possible. Now, not every country in the world issues birth certificates. So if that's the case for your fiance, if they live in a country where birth certificates are very, very hard to come by, they need some other kind of proof of their identity and nationality, where they were born, where are they a citizen, where are they from, who their parents are, who their family is. All of that information that is usually contained in a birth certificate sometimes is placed in some kind of other identity document that may be issued by the country where your fiance is from. So those documents are really, really important for both petitioner and beneficiary so that the government can see these are two legitimate individuals who we can do background checks on. That's what they really want to do. And that's why they really want those reliable, verified, vetted identity documents. The other requirements for Form I-129F to be successful include sworn statements from both petitioner and beneficiary of intent to marry within 90 days of the beneficiary coming to the US. So they want a statement from both of you signing off, saying, yes, I know what I'm getting into. I am aware of the terms of this agreement. I am okay with this, and I want to get married, and I will get married within 90 days. They want that from both parties. And then they also want evidence to back up those statements. So they want some kind of of documentation to show that you've taken steps to arrange a wedding. They don't just want your word for it. They want to know that some other people may have been invited. You have someone scheduled, you have an appointment at the courthouse, or you have a venue reserved, or you have maybe wedding invitations. If you have a big elaborate wedding plan, this is an opportunity to use some of that expense and some of the things that you've gotten together and worked so hard to pull together and look lovely and be wonderful. This is a great moment to pull some of that together and submit it to USCIS so that they can see clearly that you are not kidding around. You really are planning a wedding. But if you are going to have a very inexpensive and simple wedding, if you are one of those people that just wants a very small, intimate wedding, that's also fine, but you also have to provide some evidence. So you can't just tell them we're going to get married at the courthouse and no one else is going to be there. That's not going to work. You're going to have to get at least some kind of appointment scheduled and have proof of that, or make some kind of arrangements that you can prove. You have your identity documents, you have your sworn statements of intent to marry, you have your evidence that goes with those sworn statements that you intend to marry, and then you have to prove that you've met in person within 2 years of filing that Form I-129F. Now, it got really tricky during the pandemic, but there is an exception in the law about this requirement. And it says basically that if you are a member of a religion or a culture that has strict customs and rules against meeting in person before a wedding, or if meeting in person would cause what's called extreme hardship to the petitioner, then you can get over that requirement that you have met in person 2 years before. In the cases where you are trying to make these showings, there are a number of bits of evidence that you're going to need. And I would encourage anyone who is trying to show extreme hardship to watch our video on the YouTube channel about provisional waivers and proving extreme hardship, because everything that we talk about in that video applies in this situation too. There are a number of cases in the immigration code where extreme hardship can be a factor. And so understanding how to prove that is really important. I'm going to give you a really short overview here. Basically, in order to prove extreme hardship, you need, just like with that I-129F, you need a sworn statement. You need an explanation that is detailed and personal and from the heart. And you need evidence to back that up. Okay, so everything that you say in your statement, ideally you have some kind of documentation to show that it is true. And extreme hardship doesn't have a super concise, clear definition in the law. Extreme hardship has been found to be hardship that goes above and beyond what is just normal and expected in any kind of challenging everyday situation, right? Extreme hardship in this case could be that the petitioner has an illness. It could be that the petitioner has some kind of exceptional or unusual financial difficulty going on. It could be that the petitioner had a death in the family, or had, some other kind of personal crisis that occurred in the last 2 years that prevented travel to meet the beneficiary in person. All of that is understandable and probably rises to the level of extreme hardship. What you're going to have to do, however, is explain that in detail and prove it with document. That is what extreme hardship requires. And so just like with the provisional waivers, you are required to provide that same amount of evidence in an I-129F filing if you are trying to get out of that requirement that you've met in 2 years. We have a lot of experience in my firm proving extreme hardship and being really successful in doing so. I have to say we are really good at getting to the heart of the matter, really creating a packet of documents that can win an extreme hardship case. So if you have this kind of situation and you need help, we are here for you. Please reach out to us. Our website is jlw.law. When you go to the website, you can click on a button to schedule an appointment with me directly or with any of my colleagues in the firm. You can also call our office, 512-633-1785, and the team that answers the phone will help you get scheduled with me or one of the other attorneys. All of us have a lot of experience proving extreme hardship in our office, and we work very collaboratively. So if ever we have a case where we need additional support or help understanding how to prove up extreme hardship, we brainstorm together, we come up with ideas together. We have a lot of experience with this and we have been very successful at it. So please don't hesitate to reach out. Again, please subscribe to our channel, share the video, like the video, leave us a comment. If we can help at all, we are here. We want to help. and we want everyone to be successful. I hope all of you who are working on getting your fiancés into the United States are able to benefit from this information. Again, reach out if you need specific assistance. And with that, I am going to sign off, and we'll see you again very soon. Thank you so much. Have a good day.